I can prevent people from carrying in certain locations. Now, are you able to prevent them from having it in their condo or the apartment complex? Probably not. What you are going to probably be able to do is prevent them from having it in the common areas such as the pool, the clubhouse, the gym, and those natures, areas that are common to everyone. Those can be somewhat restricted as long as their restrictions are reasonable.
Hello, everybody. Welcome to the Property Management Law Solutions podcast. I'm your host, Attorney Tim Baldwin. And on today's episode, we have a guest that I know you're going to enjoy listening to. He is an attorney in Florida. His name is James Phillips. And so, James, welcome to the show today.
Hey, Tim, thanks for having me.
Absolutely, man. I appreciate your willingness to join me on this really important topic. I know people are going to enjoy listening about, and of course, you have an expertise in many of the subjects that we're going to talk about, which is why I wanted you to come on the show today. But before we jump into the topic, why don't you tell the folks a little bit about yourself, and so they can get to know you a little bit.
Okay. Yeah. So my name is James Phillips. I am a licensed attorney here in Florida. I'm also licensed in Tennessee. I've been practicing for about 20 years. I started off as a prosecutor up in Pensacola, Florida, where you're at, and then transferred down to Seminole County and was a prosecutor there for a little while. I then went into private practice doing criminal defense, all sorts of crimes, DUIs, major felonies, violent crimes. And then about probably 11 years ago, maybe 12, I started really zoning in on Second Amendment and firearm related cases. A lot of my practice now deals with self-defense. People who are charged with aggravated assault, murder, things to that nature that arise from some kind of self-defense situation. I handle it both criminally and civilly. I primarily am a criminal defense attorney, again, specializing in firearm related, but probably, I guess about 3 years ago, I started getting involved in civil litigation against the government, suing ATF, and I do some work for Gun Owners of America. I also handle some civil cases for Florida Carry, which is a nonprofit organization down here. Well, it's statewide, but centered in Ocala. So I've gotten where I enjoy suing the government over Second Amendment issues. It's kind of fun.
Yeah. Well, it's not a boring topic, to say the least. So that's exciting, I'm sure.
Yeah.
Good. Well,
go ahead.
Oh, sorry about that. Well, jumping into the topic, which we're going to talk about here, but as folks who are listening may or may not know, the first DCA issued a case called the McDaniels case that specifically addressed the issue of essentially the extent of the Second Amendment relative to open carry, opening firearm carry. It used to be that it was against the law to open carry, and you had to have a license, of course, to conceal carry. And so the McDaniels case addressed that issue. And correct me if I'm wrong, but basically it said that you cannot criminalize the firearm carry when it's open to the public to see. So is that kind of basically a paraphrase of that decision?
Yeah, that's exactly right. So prior to McDaniels coming out, and I think it came out September the 10th of this or 2025. So in Florida, you were prohibited from open carry with few exceptions. One of the most noted exception for open carry is when you are traveling to and from and while you're hunting, fishing, or camping. You could also open carry while heading to a target practice, and there's some other exceptions, mainly for law enforcement or agents of the government. But those were pretty much the limited times you could open carry. Now, McDaniels came along and they looked at a Supreme Court case that came out in 2022, New York State Rifle and Pistol Association, which really changed the whole field of Second Amendment challenges. And what the New York State Rifle and Pistol Association case came to is the Supreme Court said when evaluating challenges to Second Amendment violations, you have to look at the text, history, and tradition. So what happened in the McDaniels case is we had Mr. McDaniels from Pensacola who went out there open carry and had the Constitution in one hand, and he really just said, I'm going to be the patriot of this cause, and he challenged it all the way up. And the first DCA came back looking at the Bruin decision the New York State Rifle and Pistol Association versus Bruin decision. And under that analysis, the first DCA said, you know what? The pure text of the Second Amendment covers open carry. And if we look at the historical tradition of firearm regulations going back to the founding era and when the Second Amendment was ratified, there was no regulation that prohibited open carry. So therefore, the court ruled that it was unconstitutional to ban open carry. And here we are. It's left a lot of questions because, a lot of times we see legal changes to laws made through the legislative process. A bill comes out, it passes the House, the Senate, and then is signed into law. And with that comes regulations and certain standards and requirements. Here we just have a law that was completely ruled unconstitutional. So it's left a whole lot of questions out there for the public on what they can and can't do.
Yeah. Well, that's says it so very, I think, true. There are a lot of questions, and these are questions that I'm trying to help my clients walk through. Of course, my clients involve mostly landlords and property management companies and apartments. And so we have these questions about property rights versus the Second Amendment right. And there's a lot of different issues that I can foresee. So let me ask you, before we kind of get into some of those things I'd like you to talk about, do you think that there could be another case that comes out of one of the other districts in our state in Florida that may rule differently? Do you see that coming up?
I don't. Could it happen? Absolutely, it could. I think with the Attorney General of the state of Florida really getting behind this ruling and pushing and saying, hey, I'm encouraging all law enforcement agency and prosecutors not to go forward with this, I don't think we're going to see it. Also, another case that most people don't know about was actually a Gun Owners of America case that I handled for GOA. And we filed a federal lawsuit down in the Southern District of Florida challenging the open carry ban. And we actually filed it before McDaniels came out. We recently settled that case in which we reached an agreement with the state attorney and the sheriff's office agreeing that the Second Amendment allows for open carry based on text, history, and tradition, and that they themselves will not prosecute or go forward. So not only do we have a state case out of the first DCA, we now have a federal case out of the Southern District where we have a written agreement with the state agent, the state attorney, and the sheriff's office agreeing that open carry doesn't violate the Second Amendment and is applicable to those in Florida. So,
wow, is that?
Go ahead.
Is that settlement agreement open to the public? Is there some link to it?
Yeah, you can just go. It's open. If you go to Gun Owners of America's website, I believe they have it posted. You can also go to the Southern District Court. It's not a confidential agreement. So yeah, it's out there for people to look at. Wow. And if you go on YouTube, I'm sure it's out there on that too. And I know a lot of gun writers have written about it and published it on various sites in Florida. So
yeah, I didn't know about that, but that's good to know. Let's get into some of these dynamics I think that could come to play. Let's talk about the property rights versus this decision, this McDaniels decision. So, you have primarily apartments. We have a lot of people convened into one site, could be literally hundreds of people, and so the question comes down to: can the landlord, property management company, can they limit that? Can they restrict that? What kind of rules do you think the courts would uphold in those types of issues? Can you address that for a little bit?
Yeah, so, some of this is going to be a little bit of speculation because, again, we just have a court ruling finding a statute unconstitutional, and we don't really have much guidance. And there's a lot of I want to say, false information out there. I don't think it's intentionally falsified. I just think people are uneducated and they don't really know. And a lot of people are saying for open carry that you're restricted to those locations that you are restricted for concealed carry. And if we look at the Florida concealed carry statute, it's Florida statute 790.001, which encompasses those with a concealed carry license, which is a different statute, 790.06. Inside 790.06, we have subsection 12, which lays out a bunch of locations that are prohibited by law from carrying. And these are separate from federal. We know under federal law, you can't carry in federal buildings, post offices, things to that. But if we look at the prohibited places under 790.06, it doesn't specifically mention private property in there, but we do know that private property owners can prevent those from carrying, whether it's concealed or open. Now, there are some somewhat limitations, like when we look at housings, like apartment complexes and stuff, Section 8 housings are going to have different kind of restrictions than a privately owned, because Section 8 houses encompasses government funding. So under those situations, you're not going to be able to really restrict Second Amendment rights, because that's a constitutional right, and we have a government entity, in essence, doing it through the Section 8 housing. And there's been some litigation on that. Now, as far as privately owned housing complexes, it's just like my privately owned home. I can prevent people from carrying in certain locations. Now, are you able to prevent them from having it in their condo or the apartment complex? Probably not. What you are going to probably be able to do is prevent them from having it in the common areas, such as the pool, the clubhouse, the gym, and those natures, areas that are common to everyone. Those can be somewhat restricted as long as their restrictions are reasonable. Now, you're not going to be able to permanently restrict someone from carrying their firearm from their car to their condo that they own just because they pass through, but you can prevent them from bringing it to the pool or to a clubhouse, or possibly even a clubhouse meeting involving the HOA association or the condominium association. But those are private property issues. And we have James Utmeyer, who came out, the Attorney General, in his statement after the McDaniels case, and he was very clear that, you know, this should not affect property rights. So I do think landlords are going to be able to prevent people from going in common areas. I do not believe the law is going to allow them to permanently keep people or 100% prohibit them from having firearms in their apartments or condos that they lease through their agency. Now,
it's going to be interesting to see, James, because I do know that there are some apartments that do in fact restrict firearms altogether. It's just an outright rule. So I would venture to say eventually maybe that's challenged. You know, maybe there's someone, a tenant, who wants to carry, or not carry open, but have possession of firearms in their unit. So I can foresee that being challenged, as well as you know, these, you know, if you're in the military, if you're a police officer, obviously that comes with your duties of employment. So I can see issues in that regard as well. But let me ask you this, James, because this is the one that I think is really going to be maybe perhaps difficult for property managers to wrap their minds around, as well as creating a tangible policy and procedures manual for employees. And that is to say, what if you see someone, it could be even a guest or just someone who's visiting the property, and they're not necessarily subject to a lease or those types of things, and they see them enter the property with open carry. It could be a long rifle, it could be a handgun. I mean, with the McDaniels ruling, do you think at that point that if they were to call police just on sight of seeing something, that poses a problem for them?
You know, I don't think it really poses a problem for them. I don't think they're going to have any issues. I mean, as far as criminally, there's definitely no issue in calling and saying, hey, I think this is suspicious. Now, civil, as we all know, you can be sued for anything.
Yeah.
So yeah, if you call the cops on someone, that person may file a civil lawsuit against you. Now, I don't think that's realistic. I don't think many attorneys would take that. Again, I don't know that, though. That's just speculation. So that would really be the only liability you would be facing if you called and reported. But I just don't see it happening. I think you're free to do it. Now, whether law enforcement will respond to it, that's a different story, you know, based on their policies and their procedures, what they do. You know, because now that it's law, you can't just detain someone to conduct an investigation just because they're following the law.
Right.
Now, you know, kind of backtracking, if that's okay, you made a good point about some of these apartment complexes prohibiting firearms completely. And I've seen those too. And it brings up a whole issue of you contracting away your constitutional right. And I think there's a big difference between an apartment complex where you contract your rights away to have a lease compared to a condo that you purchase and actually possess yourself. So I think those are two different issues to look at. And it's something I haven't seen a whole lot of litigation. I haven't seen or had anyone come to me where they lived in a condo where they purchased it and that they were told they can't have it in their person. I have seen the issue of the apartment complex, and I actually had a gentleman who was in a Section 8 housing issue, and they were trying to prohibit it. And I know he was going to litigate that issue. And we've seen cases throughout the country where there's been some litigation on the Section 8 housing. So I think what we could see, even though Section 8 is different, because we're talking about government being involved, I still think we'll see a little bleed over into some of these apartment complexes who are completely wanting to prohibit firearms general. Now, what I tell people, because I have had people call and say, hey, this apartment complex says I can't do it, go somewhere else. It's just like when you see a no gun sign, which is a whole different issue, at Chipotle or some other restaurant, take your business somewhere else. If they don't want to respect your right, then go somewhere else, because they do have certain property rights. We have to respect their rights just like they need to respect the Second Amendment rights. So it's a fine line,
Yeah. Well, with this, the Section 8 or even the public housing is going to be another interesting one, because they're bound by federal regulations,
right,
to keep and secure reasonably the safety and well-being of tenants around them.
That's right.
So when you have some housing areas that are high crime, and believe me, I mean, it's not uncommon to have to deal with gun shooting violence within these housing projects.
Completely agree.
And so when it comes to practically managing that issue, when you have a lot of gun violence in a particular project, again, I think the question becomes, is just the fact that you see a firearm on the property enough for the manager to begin to take action? I mean, I think based on what you've said, you may agree that yes, they can take certain action to make sure that the person, for example, the person who's carrying the weapon, I mean, are they a convicted felon, or do they have other criminal purposes on the housing? What do you think about that, the competing interest of safety versus the McDaniels decision?
That kind of goes back to what the courts previously looked at. We had a open carry ban challenge go all the way up to the Florida Supreme Court in the Norman case. And in the Norman case, it was pre-Bruin, pre-2022, and they looked at more of the interest balancing test. But the Supreme Court has now weighed in on this. The U.S. Supreme Court, the law of the land, has weighed in and said that's not how we challenge these anymore. It's strictly text, history, and tradition. Mm-hmm. So as far as the safety aspect, I understand it. I get it. But I don't know if safety alone trumps someone's constitutional right to carry a firearm. And just because someone is openly carrying doesn't mean that they're a threat. Now, we still have a crime on the books, improper exhibition of a weapon. So if someone is carrying a firearm in a rude, angry, careless, or reckless manner, then that may be grounds for law enforcement to stop, detain them, and conduct an investigation. But just seeing someone walk across a property open carrying, I don't think it's going to be enough for law enforcement to really do anything. I mean, I guess if it's a private property and they're concerned, they can call and the officer can say, hey, the owner of this property doesn't want you doing that. And they can, in essence, tell them, if you come back, you'll be trespassed. But that's really the only mechanism they have, because based on the McDaniels and the court saying it's constitutional for you to open carry, they're not committing a crime anymore.
Yeah. I wonder if, my mind is, there's so many things I want to try to flesh out, but it's too much probably just on this show. But, one of the major risks of liability for a landlord, especially apartments and public housing type situations, is their security, right? The security. So if someone walks onto your property and starts shooting, and you didn't take any precautions or any safety procedures to deal with that beforehand, as you well know, James, you're probably going to be sued. In fact, some of my clients have been sued for situations like that.
I would be willing to bet on that.
Yeah. And so with the McDaniels case, then it's almost like now the landlord's responsibility almost becomes heightened in the sense of we really need to know if you're going to have guests come onto this property, we need to know who they are. Right. And I don't know if it goes so far as to say we need to have a background check, but I'm just thinking of one case in particular that one of my clients faced, and it had to do with the tenant's boyfriend entering the property, and he didn't live there, so he was a guest, but he ended up shooting and killing her. And so, of course, the decedent's estate sued my client for basically breach of certain obligations. And one of them was not checking to see who's coming or who's frequenting the property to verify if this person, was violent or had other purposes. And so that exposure to liability is real. And so now I wonder if, since the McDaniels decision has come out, it's almost like it heightens the landlord's obligation to really make sure if you're coming onto this property, especially if we see that you have a weapon on you, we have to do something beforehand.
Tim, to be honest, I think you bring up a great point that I haven't really thought about, the whole issue of having the duty to protect your tenants and those that live in your facility, and the standard for that compared to constitutional. I think it's a great point. And like I said, it's not something I really thought about. From that standpoint, I guess implementing some kind of policies that, your tenants have to be pre-approved, I guess they could go that route. But yeah, I would agree with you. It does somewhat cause a heightened degree for your clients who are put in the predicament of, hey, we have the constitutional right. This guy is not breaking the law per se just by looking at him, unless he's doing something suspicious. But we still have the obligation to protect those who are leasing from us.
Yeah.
I don't know the answer. A check-in procedure, a guard gate, which obviously brings more costs to the landlord.
Yeah.
There's going to have to be some procedures in place. I don't know what those would be, because we have to, again, remember, we have constitutional rights. You can't just prohibit someone per se from doing something that they're legally allowed unless they're on the private property. But then again, when we're talking about these condos and these apartment complexes, there's only certain areas that are really considered common areas. So you can keep them from that, but how do you keep them from going in there? I guess you can track that, but obviously that may keep you from getting certain tenants.
Yeah, well, and also the landlord cannot contract with the guest, right?
That's true.
So, and then we have this other issue about, can you lawfully just prevent someone from having a guest? Probably not. There could be limitations and rules, of course, but just saying you can't have any guest on the property at all, that's probably not going to apply. Let me skip it, because I know that topic is really big, and I think we've covered a little bit of the ground there. But there's another one I want you to comment on, and that has to do with a tenant's request for reasonable accommodation. So under fair housing, if the person has a disability, and the situation I'm thinking of is probably some kind of a stress disorder or mental disability relating to firearms. It could be a veteran, it could be someone who's been through a gun violence scenario before. Maybe they're a victim of domestic violence, and so they have this disability that is triggered by even the sight of firearms. So let's assume that the apartment has a policy that, hey, you can carry, but it has to be within your unit. Maybe you're restricting certain common areas to have open carry. But let's just say that the tenant sees that they have a neighbor that's open carrying around that unit, and they make a request for accommodation to say, hey, I need you to change your rules because I need an accommodation to address my disability. How do you see those competing interests as well?
I don't see it going well for the person who's asking for the accommodation. We're talking about something that is, I know it's not really generalized here in Florida because it's somewhat new, but open carry. Before Florida became open carry, there was only 3 other states besides Florida that had banned open carry in its entirety. So I don't think it's such a, how do I say this? I don't think it's so all-fetched now that it should trigger someone in that situation. Again, I am not saying medically wise, but from a legal standpoint, I think because it's a general constitutional right, that it's not so unique, I'm not so sure a person asking for accommodations for that would be successful. And I don't think if someone who had a post-traumatic issue from firearms and they have, I don't know if a relapse or an episode based on seeing someone, I don't know if the liability would go to the landlord for not protecting them, because I think that's such a very specific and unique situation. And again, I'm not a property law attorney, but my general understanding is you have to protect them from reasonable harm. Mm-hmm. This is a very, very finite specific, and I don't think you're going to be able to ban someone from having a firearm, whether it's concealed or open carry, just because a tenant may have an episode or relapse into some kind of stress situation.
Yeah. So from your perspective, the request at that point wouldn't be reasonable. Therefore, it's not. There's no obligation to accommodate.
I don't think that's reasonable.
Yeah. Yeah.
I hope that answered your question.
Yeah. I mean, that's going to be the question. I mean, that will be the issue for if it's challenged, of course. Right. Is for the court to determine whether that request is reasonable or not. And as we know, the word reasonable can be applied and interpreted perhaps differently based on the facts. So let me ask you about this one. What about insurance coverages as well as maybe premiums? Okay, so insurance companies now that we have McDaniels out there, as it relates to liability insurance or property insurance, do you think, or have you seen any direct correlation with the McDaniels decision and as it relates to insurance coverage and premiums?
I have not at this point. No one has brought it to my attention. Most of the time, homeowners insurance, umbrellas insurance, they'll cover certain firearm related incidents as long as it's not an intentional act. So I don't know. I don't see how it will affect premiums and stuff like that just because someone is now open carrying, but I don't know that. I just haven't seen it. I haven't heard anyone having any issues with that.
Yeah, I kind of wondered if the insurance providers are going to maybe change or amend some of their terms of coverage to specifically address open carry, maybe on their properties. I don't know, but I presume that if the insurance providers impose some obligations on the landlords, that potentially, I guess, could be challenged as well under McDaniels to say that basically it's a backdoor way of regulating open carry rights and that sort of thing. So to me, it's just a question at this point because, with risk comes cost. And so I kind of wonder if landlords are going to see increase of premiums and that sort of thing.
I don't know how it changed when concealed carry, we've had concealed carry for a long time. And then 2023, we had permitless carry come into effect. Prior to 2023, you had to have a concealed carry license to carry a firearm concealed on you. Then 2023, it changed to permitless carry where you don't have to, but you have to meet certain things. I'm not aware of any of the insurance increasing at that point when it went to permitless carry. So with that correlation, I wouldn't expect to see it with open carry. I know they're different, different open versus concealed, but it still comes down to carrying a firearm. So if we didn't see an increase with permitless carry, I would not think we should see one with open carry because it's just carrying a firearm. It's just the manner in which you're doing it.
Yeah. Now, I would imagine that you deal with risk protection orders as well. With some people call it the red flag laws.
Yep.
Florida does have. Yep. So 790.401 is the statute in Florida. Speak to that if you would, as it relates now to the McDaniels decision. And of course, if you could tie it in somehow to property managers, that would be cool.
Yeah. So in Florida, we have extreme risk protection orders, often commonly referred to as red flag laws. And what it does is it allows a police agency, and only an officer can request a extreme risk protection order. They can petition a court to have someone's firearm rights temporarily taken away. And the standard is, does that person pose a risk of danger to himself or to others by possessing firearms or ammunition? And if a court determines so on a temporary basis, it can be done without a hearing held, and the officers go and they take the firearms and ammunition. Then a final hearing will be set in which evidence will be presented. And then the standard is a clear and convincing standard, that it has to be clear and convincing that the person who is subject to the risk protection order poses a danger to himself or to others by possessing it. If the court finds, then they can enter a 1-year, 12-month order prohibiting that person from having it. It can be extended and it can be shortened. Unlike restraining orders or injunctions, it's not a permanent. It's only for a set period of time. Now, what we could see happening as far as landlord tenants is if the landlord becomes aware that a tenant is subject to a risk protection. In other words, if they're put on notice that a person is not allowed to have a firearm, then I think if they see that person with a firearm or ammunition, I think they're going to be under a duty to call law enforcement and report it immediately to sever their liability. Because if they know someone is not allowed to have firearms or ammunition and they are put on notice that that person does in fact, then I think that definitely creates a liability for them, and they could find themselves, under a lawsuit if something bad happens.
Yeah. Do you know? I have a couple of questions in that regard. So, do you know if once the court enters an order to restrict or revoke their right to possess for that year, presumably, is there some kind of a notice that's sent out to maybe friends, family? I mean, what kind of notice does the public have about this?
They don't really have any. What happens is if it's entered, it is sent to the Department of Agriculture to let them know if they have a CWFL, the Concealed Weapon or Firearms License, that is being revoked. It's also sent to FDLE, so if they try and purchase it, it's flagged. But it's not sent out to the public. It is public. The public can see it if they go to the clerk of the court's website and they go enter the person's name and they type it in and go. But other than that, they don't get any kind of notification.
Do you know if, because when landlords do a background check, they, in general, they'll see their criminal background, but I don't think they're going to see a risk protection order pop up.
No, I think you're correct. They're not going to see that because when they run the background check, it's more of an NCIC background check. That's strictly criminal. So no, I don't think they would see it. I don't know if there's more detailed background checks out there that would allow, someone to go through the clerk of the court's website. Because again, it's all public record.
Yeah.
It seems to me we're going to do it that way.
Yeah, and it seems to me, and this is just me, from the standpoint of protecting landlords and their liability, is that it would kind of be good, I think, that if someone is subject to a risk protection order, that it actually shows up on an NCIC. I mean, I know it's civil in nature, but at the same time, it has some criminal implications. So that whenever someone does a background check, they can see that this person should not be possessing firearms, which is a big deal when it comes to, a landlord-tenant relationship. But without that being the case, other than going to every single county clerk of court website and looking up their name, I don't think there's a statewide system that Florida provides for that kind of search. Is that correct?
You are 100% correct. And I think the fact that there's not, that helps as far as liability purposes go, because it's not reasonable for a landlord to go and check every person through every clerk of the court in the state of Florida. So again, unless there's some way to show that the landlord had some kind of actual notice of it, which they're not, unless the person tells them or if they somehow find out, I think it limits their liability. Yeah,
I think it does too. I can tell you though, and for those who are listening who are landlords or property managers, it's so important that within your application documents as well as your lease documents, you need to put that obligation on the applicant and the tenant to say, hey, you need to disclose to us if you have been subject to risk protection order. And if you are subject to one, even during the term of the lease, you need to notify us so that way the landlord can take adequate protections in that regard. Would you agree with that?
Oh, 100%. I think that's great advice. Just to go a little step further, they may want to include something about if you're subject to any kind of injunction for repeat violence, sexual violence, or domestic violence. Because with those permanent injunctions being in place, that also prohibits people from having firearms.
Yep. Exactly. No, I have that very thing. Try to be as comprehensive as I can in these documents to help my clients. But yeah, any sort of injunction that prevents you from possessing firearms, it could be domestic violence, it could be another, if you're charged with some crime, it could even be a misdemeanor. Many times a court will, as a condition of your bond, restrict you from possessing a firearm. So that's the type of information that landlords should impose upon those tenants to disclose.
Absolutely. Also, not just the bond condition, but if anyone is placed on any form of probation, they become in essence, a prohibited person, at least while they're on probation.
Yeah, absolutely.
No.
Let's see here. I think I always try to keep these around 30 minutes, James, just so I can respect your time and the listeners. Do you have any sort of closing comments, sort of wrapping this up and just kind of giving the listeners a little golden nugget, if you will?
Yeah. The best advice I've been giving people is it's not what people want to hear, but it's the truth. We're just going to have to wait and see. This is still relatively new. I mean, it's less than 6 months new. We don't have a whole lot of guidance from the courts, which is where we're going to get it. We have our legislative session coming up. There are no bills on the dockets that have been pre-filed that really discuss open carry. There was one originally, but it has already been withdrawn. So we're really going to have to wait and see. The best thing I think for landlords to do is to protect themselves. I think you give great advice about having documentation, about red flag laws, injunctions that their tenants must disclose. In the abundance of caution, if you feel like something isn't right, there's no harm in at least calling the non-emergency line, letting law enforcement know. Whether or not they'll respond, I can't tell you. Open carry is now the law in the state of Florida. It's a right, it's a constitutional right that's protected by the Second Amendment and that the Florida courts have deemed is applicable here in the state. I think as time goes on, people will get more used to it. Right now, it's something new, and with anything new, obviously, we're a little scared of change. But if we look at all the other states, and again, before Florida became a open carry state, there was only 3 other states that banned it completely. So this isn't really a new thing for everyone else. It's just new for us here in Florida. And if we look at other states and what's been happening in those states, we haven't really seen a whole lot. In fact, we've seen no increase in crime since open carry has passed in those states. And I don't think we've seen it here in Florida. So, just be wary of it, be cautious, respect others. As long as someone's not flagging or being reckless or threatening with their firearm, then they're probably in compliance with the law. Protect yourself. If you don't want someone on your property, you have the right to tell them not to be on your private property. Again, with the landlord issues and the condos, that's really only going to be applicable for the common areas, the pool, the clubhouse, things that really are your domain and not specific to that tenant. You're not going to successfully, for the most part, be able to keep a tenant from having a firearm in their house or in their residence. So, we're just going to have to see what guidance we get from the courts, just be wise and, look out for your best interest.
Yeah. I think I'll follow that up with just, consult with your attorney. I mean, if you're a landlord, you need a landlord attorney.
Absolutely.
Your all your documents, as we've been talking about in the podcast, all of your application documents, your lease, your community rules, they need to be clear. Common areas need to have proper posting of signage and these types of things. I would also say, try to form a good relationship with your sheriff's office and police office as well, and maybe get some guidance from them. I'm sure that they already have some protocol in place since McDaniels, and so you can ask them, hey, what should we do, or can you provide us guidance? I know, like even in Escambia County, our sheriff's office does a really good job of presenting even public seminars and meetings and such, so that they can provide the community with helpful information. So it's just a matter of getting involved and making sure you're informed and have those good relationships. So if something does happen, they know it's legitimate. They know you're looking out for the best interest of the community and are trying to do the right thing. So,
no, I think that's great advice, Tim.
Well, James, I appreciate it so much that you came on the show and talked with me about this very important topic. It's exciting to see what you're doing. You're one of the guys from Pensacola that I didn't get to meet whenever you were at the state attorney's office. I had just left prior to your arriving, so our passing just missed each other. So, but anyways, nice to talk to you now, and it's good to see that you're doing well in your practice. And of course, if folks want to contact you, what's the best way of doing that?
So they can reach out to us. Our phone number is 321-332-6864. We also have a website. It's thefirearmfirm.com, firearmfirm.com. We post a lot of information, blogs, of course, related to Second Amendment. And we also have a YouTube channel, The Firearm Firm, so they can reach out there with any questions. Thanks for having me, Tim. I really enjoyed it. I hope I was able to provide some insight. Unfortunately, all of us are treading into new waters right now.
Yeah.
We're just going to have some guidance, but I think we'll be okay.
Yep.
So,
well, it's nice to have experts like yourself in your areas to be able to refer to. So I greatly appreciate your input. It was very valuable to the listeners and to myself as well. So thank you for that, James. I will put your information in the notes for anybody who wants to contact you. Of course, we'll post this video and audio podcast for everybody to listen to. So I'm sure they'll find it very interesting. All right, James, that's going to do it. I appreciate your joining us. Everybody, thanks for listening to the show today. Just if you haven't followed this podcast already, go ahead and do that. We post at least twice a month, sometimes more. So hopefully you'll find it very valuable. All right, everybody, thanks for listening. We'll see you on the next show.
Thank you for listening to this podcast. Nothing in this podcast was legal advice or creates an attorney-client relationship. Reach out to us at www.pmlaw